The all cap name is trust that I am a beneficiary of. My name is not spelled in all capital letters. I have a court order decree saying that.
Okay, Mr. Bay. Mr. Bay, do you have an attorney representing you, sir?
Attorney General.
No, and I get what you're saying, but we're not doing that because that's not how we operate. Those are not the laws under which I am required to conduct court. So we either gonna do it my way or we're gonna put you on.
We understand the rules of the court. We understand the rules of the court. I got you.
The United States has no constitutional capacity to exercise municipal jurisdiction, sovereignty, or eminent domain within the limits of state or else.
Hold on.
I've denied your motion. This is the correct court. We have jurisdiction, so move on. You can disagree with the court's order, but you can't make it better by just continuing to argue about it. So let's move on to that other motion that potentially is dispositive. The stop.
All right, DeMarcus Cantrell Brown.
We are going to be submitting a withdrawal to you. You should have it shortly.
All right, Mr. Brown, are you represented by somebody else?
Yeah. For the record, I am DeMarcus Bay, the implied surety for DeMarcus Cantrell Brown. And I would like to file a motion in the court for additional 30 days for me to seek counsel.
Okay, so Mr. Bay,
Yes.
aka Marcus Cantrell Brown, so you're seeking a continuance to get new counsel?
Yes.
Okay, do you have someone in mind, sir?
I not right now. I'm seeking counsel.
Okay, so here's the thing. I'm going to give you a continuance for 30 days, or I'm sorry, until January 5th. But by that time, you need to have counsel on board when they come back so that they can talk to the state to determine if there's anything they can work out on your case, or if they need to get all of the information necessary for a trial, if that's what you choose to do. So by January 5th, I will expect that you will have counsel.
Well, I have paperwork on the docket that haven't been rebutted. I have affidavits of truth that haven't been rebutted.
Okay, sir, we don't do affidavits. People have to appear in person because there's a confrontation clause in the United States Constitution that says witnesses, you have the right to confront witnesses in person. So we don't do affidavits, okay? If you have witnesses that are going to present testimony or evidence on your behalf, then you have to have them come to court and be sworn in and testify at that time, okay? So we're not doing any dismissing and all of that stuff. No, sir. When you get your counsel, they'll be able to discuss it with the state, and then y'all can present whatever to the court.
And the accusing deputy must be present too, right? Okay.
So the people always say that, but here's the thing. The state gets to choose whatever witnesses they wish to bring, just like your side gets to choose whatever witnesses you wish to bring. You can't rely on them to bring the person that you want. So if you want to subpoena someone to appear for trial, then you need to subpoena them. You cannot rely on the state to bring your witness. Okay.
Okay. I got you. So,
all right. Anything else?
And jurisdiction can be challenged at any time, right?
No, sir. Jurisdiction rests with this court because this is where the locus of the incident is.
Well,
Mr. Bay, let me just explain something to you. Mr. Bay, listen to me.
Okay.
I went to school for 3 years for this. That's full time. If I had gone part time, it would have been 4 or 5 years. And I have been working since, oh Lord, I ain't gonna give my age, but I've been a lawyer and a judge for quite some time. I've been a judge for 10 years as of this year. A lot of times people come before me because they've learned stuff from other people, or they've gone online, or they've read it themselves. But I tell you, it doesn't work the way you think it works. And so there's a set of statutes, cases, procedures, all of those things that we have to learn. In fact, let me show you something.
Well, how do you have?
Wait. You see this book right here? This is just this year's edition of all the stuff that I have to be able to find to figure out what's going on in your case. This is just this year's edition. And I got a book like this that includes evidence and procedure. I got a whole wall of books. So when you come in here challenging jurisdiction and all of this stuff people have taught you, it's not
can I show you my Black Law Dictionary?
No, sir. Because Black's
And
Law,
prove it.
that's a dictionary. That's not the full case. You know, you come in with all of these ideas about how you think the law works, but every lawyer in here has done at least 3 years of law school and trainings, trials, all of those things. So you're not going to change the way we do things. So the best thing to do is to get an attorney who can talk to the state about your case, and then we can get this resolved. Your case is pretty simple. You got traffic offenses.
Well, I still want you to prove on the record that you have subject matter jurisdiction, personal jurisdiction.
I'm not proving anything on the record, sir. I wear the robe. They put me in this position. I've been here 10 years. If I didn't have subject matter jurisdiction, I wouldn't be here.
So
All
you
right?
say it's not a difference between public and private for the record. There's no difference.
Sir. Sir, get an attorney.
Okay, all right.
Thank
January
you.
5th.
Yes, sir.
Okay.
And Mr. Bay / Brown, you've indicated that you wish to have an attorney, so I'm going to rely on the fact that you're going to have an attorney. Don't come back here with the same stuff, and I already told you it's not going to work.
So you're telling me United States codes don't work?
No, I'm telling you, you don't know them. So first
I have
of
it
all,
right here.
the United States codes don't work in Georgia because Georgia has its own code, OCGA.
So the meaning of driver is different in Georgia.
Yes, sir.
But according to 49.
Mr. Bay, I'm not doing this with you. Get an attorney.
Okay.
Thank you, sir. You're free to go. We'll see you on January 5th at 11 a.m. So DeMarcus Contrell Brown.
I have interest in that matter. Is the defendant in error free to go?
If the who, what?
Is the defendant in error free to go?
No.
Well, let the record show the defendant in error is ordered to stay and participate.
Okay, who is the defendant in error? That's a new one for me.
The all cap name is trust that I am a beneficiary of. My name is not spelled in all capital letters. I have a court order decree saying that.
Okay, Mr. Bay. Mr. Bay, do you have an attorney representing you, sir?
Attorney General, my Attorney General is online. You may speak to me, sir.
Is the Attorney General, Mr. Bay, hold on, let me ask my question before you tell me something crazy. Is the Attorney General a member of the State Bar of Georgia? I'm a
non-state actor. I'm a foreign national. Matter of fact, I filed
Mr. Bay.
oath of office.
Mr. Bay, I don't care if you were Alexander Putin, the premier of Russia. If you are in Georgia and you're represented by an attorney, that attorney would have to be a member of the State Bar of Georgia. Foreign national or not. Just as if you went to another country and you had an attorney represent you, that attorney would have to meet the requirements of that country and of that state. Okay, Mr. Attorney, Mr. Bay, hush. Mr. Attorney General.
I'm trying to set a record.
Mr. Bay, Mr. Attorney General, are you a member of the State Bar of Georgia? You want to unmute for me?
Speak, bro. Get off mute.
What's going on is he's a member of a foreign state corporation, basically doing business in Georgia. So
Okay,
basically,
sir, that's not what I asked you. No, sir.
I get what you're saying, man.
No, and I get what you're saying, but we're not doing that because that's not how we operate. Those are not the laws under which I am required to conduct court. So we either gonna do it my way or we're gonna put you on.
We understand the rules of the court. We understand the rules of the court. I got you.
Okay. Are you a member of the State Bar of Georgia?
No, I'm not a member of the Bar of Georgia.
Okay,
what I'm trying to realize
as he can represent himself,
you need to take consideration on that matter on how he's doing business in Georgia.
He can represent himself, or he can be represented by a member of the State Bar of Georgia, but he cannot have you represent him or purport to represent him. Okay, that's not going to work. All right. So, Mr. Bay, do you wish to choose someone who is a member of the State Bar of Georgia to represent you, or do you wish to represent yourself?
I invoke my right to remain silent as the beneficiary of DeMarcus Contrell Brown estate.
Okay, sir. So, sir, you're invoking your right to remain silent, which means that you do not wish to enter a plea that
I
would
plead to be released.
that would resolve your case today. As such, the court is going to enter a plea of not guilty for you.
I object. You cannot
on-
practice law from the bench.
and
Violation
put you on
28
a
USC 454. Judge practicing law from the bench.
and put you on a trial court, on a trial calendar so that your case may be heard at
I
trial.
object.
All right, sir. Thank you. You'll get notice in the mail. If anything
I
changes
object.
about your, if anything changes about your address, then you can go ahead and let us know by coming
I
into.
have no. I demand evidence hearing.
You will have that at the time
I
of the
demand
trial,
evidence
sir.
hearing.
You're not going to have an evidence hearing today because that's not what we're here for. This is a
You are
regular.
dishonorable. I got your oath, Tammy Long. Hey,
So, Mr. Bay, I'm going to enter a plea of not guilty on your behalf. You'll have a trial at which time you can have an evidence hearing. You'll get notice in the
you
mail.
in violation of Article 6, Section 2 of the Constitution.
Your notice in the mail, then you can appear for hearing with whatever evidence that you wish to
I
present.
object.
Although you are not required to present any evidence or testimony because the state has the burden of proving the case against you. Thank you, Mr. Brown. You're free to go at this time.
I object.
All right, Kevin Jermaine Burrows.
Settlement agreement that's been filed by the defendant, Ms. Jennifer Geiger. With us, we have, and I unfortunately cannot see people's names. It's too far away from me, but I do see that we have with us, let's see, we have the plaintiff, Kevin Geiger. You're with us, is that correct?
Yes. Can you hear me?
And I can hear you, and also Jennifer Geiger as well, is that right?
Christine is here.
All right, I said, is it Jennifer Christine, but you go by Christine, is that right?
That is correct.
Okay, thank you now. And also we have Ms. Jordan here as well. And are there any other parties that are present in this case? It doesn't appear so. Discuss where we go from here. Ms. Jordan, I'd like to hear from you as to today's motions. First, it looks like we have the property settlement enforcement issue that needs to be resolved before we do the pro count. Is that correct?
We're here on our motion to enter the judgment. I have Ms. Schmelzer. I'm appearing on behalf of Ms. Schmelzer. She has submitted a proposed judgment of divorce to the court. We ask that the court enter it. Whatever defendant has filed, I'm not sure exactly what it is. It doesn't specify what she's asking to enforce, but we are standing by our motion today. There's no reason why defendant, she has refused to sign the judgment, which comports and incorporates the property mediation agreement that was signed by both parties on May 7th, 2024 at mediation. She has indicated to us only that she does not agree with the judgment, but has not specified what she hasn't agreed to. As I said, the judgment incorporates the signed mediation agreement of the parties that is binding. There's really no reason for her to refuse signing the judgment. Seems that there's been a long pattern of her delaying proceedings throughout this matter. And we ask that the proceedings, that those delays cease at this time and that the court enter this judgment, which again comports with the party settlement agreements that were placed on the record in open court. And the mediation agreement for the property is attached to this motion as well. Due to the delays and the unreasonable refusal to sign the judgment, we are also asking for an award of attorney fees to plaintiff for him having to file this motion and for the delay. Thank you.
I object. I sent documents regarding jurisdiction.
Hold on. So Ms. Geiger, this is how this works. I will call on you since you're representing yourself. We're going to talk in just a moment in order to speak, because we are actually making a word for word record. And I need to be careful of that record so that if there's any appeal or any review, that it's clear who is speaking and when. So hold tight. I'll get to you in just a moment. You did file first a document on November 13th that indicated that you called it a motion to enforce a property settlement, and you indicated that there was a new mortgage dated 11/15 of 24 that he was closing on, number one, meaning the defendant, and also that he failed to disclose Grand Traverse Band income as well as a trailer that he owns. And so as a result of those matters, what is it that you are seeking? What are you asking me to do?
Second of all, the plaintiff has failed to provide me with the pistol that was awarded in mediation and signed upon. Second of all, the information in the plaintiff's divorce paperwork is incorrect. I do not reside in Grand Traverse County. I reside over 200 miles outside of Grand Traverse County. That needs to be corrected. And furthermore, I have never gone by Jennifer Geiger Roundtree. Roundtree was spelled incorrectly in her paperwork. And according to the Michigan law, the plaintiff nor no one else.
All right, you've listed off a few issues. And first, before I hear from you any further, I need to advise you that you're representing yourself now in this case. It is always smart. It's very smart to have an attorney represent you, particularly in a divorce action like this. Someone who knows the law, knows the rules of ethics, the rules of procedure, the rules of evidence. And the reason for that is because when you act as your own attorney, you're held to the same ethical obligations and the same level of knowledge that someone who's gone to school for 3 years to become an attorney has to have. So I'm advising you strongly to retain counsel with regard to this matter. Are you seeking to proceed now on your own? All right, that's not what I asked. Listen to my question. Are you ready to proceed then today, even though I've advised you that it makes good sense for you to have an attorney? Do you wish to proceed today?
Your Honor, I have, in the last 5 months, I have sent 5 notices to participants in this case, including yourself. Never at any time during this 5 months or those 5 notices have the matters in the notices been addressed. Therefore, I'm demanding that jurisdiction be put on the record, as well as oaths and a surety bonds for all people present.
All right. So, ma'am, you're not answering my question. You're raising issues that, frankly, are a bit concerning because but I'm going to ask you one more time. Are you proceeding today without an attorney?
Do I require due process under the law?
All right, you're
Do I
answering the
receive
question.
due process under the legal?
All right, now let's get back to my question. It appears to me that you intend to proceed today without counsel. You aren't responding to my question. I hope that ceases now. I'm not trying to box you into something. I'm merely trying to get your divorce taken care of. So let's go ahead and see if we can proceed on it. Back to your motion that you filed to enforce the agreement that you had regarding property settlement. That property settlement is generally, and I assume this is the case, generally rolled into the judgment that Ms. Jordan is seeking to enter today. And once that is the case, you'll have the ability to enforce if it is not complied with. You're seeking to enforce a property settlement prior to the entry of an order is not procedurally accurate. You do need to wait for the order to be entered to be able to enforce. Now, if there was something in that property settlement that required that for example, the pistol be transferred by a certain date, well, that's certainly something that I would consider. But otherwise, you do need to wait for the order to be entered, and it's the order that is enforced, not the property settlement agreement. Do you understand that, Ms. Geiger?
No.
Okay, let me explain it to you again. The motion that you filed is called a motion to enforce a property settlement. Done, that is an agreement signed by the parties with regard to the disposition of their assets. And that's not an order of the court until it is rolled into or becomes part of a judgment of divorce. Now, the judgment of divorce is what has been moved to be entered today. And that's what Ms. Jordan has asked me to approve, the judgment of divorce in this case. Once that is done, if the terms of the property settlement are included and have not been complied with, then you would certainly have the ability to move to show cause why the plaintiff should not be held in contempt of court for not comporting with the terms of the judgment. Do you understand?
I do not, because you signed the property settlement back in May or June. All other matters within the property settlement were taken care of. Why wasn't that, and why isn't that being enforced? It should have already been taken care of. In fact, I received an email from Ms. Smeltzer with directions on what to do to take care of that item of the property settlement, which I did do, and Mr. Geiger failed to acknowledge any of it. He was given the permit in October, and he refuses to comply with it.
All right, let's go ahead and hear from Ms. Jordan then as to the matters in the motion to enforce the property settlement agreement.
Regarding the transfer of the guns within the judgment, it does say that everyone is to cooperate and sign paperwork to effectuate the transfer of the guns. That is something that is, part of their mediation agreement that was to be incorporated into the judgment, just as you have explained your understanding. That is my understanding as well.
Is there an order in place at this time regarding the matters set forth in the motion that's been filed by Ms. Geiger, Ms. Jordan?
An order, I'm sorry?
Is there an order with regard to the disposition of the marital property that the court has signed already?
The only person that has signed it in addition to Ms. Schmelter and the parties was the mediator, Ms. Linda Marsh Raids. But I do not see that was submitted and understand it was submitted to the court, but it was signed by the mediator on May 7th at mediation. And that is attached as Exhibit B to our motion.
Thank you. That would be the normal process. Normally, the mediator will sign and approve it as an exemplar of what it was that was agreed to by the parties. And then I sign it, Ms. Geiger, for your information, I sign it and it becomes an order, it becomes law between the parties once the court's signature is on it. I haven't signed it yet. And I haven't signed it yet because we're waiting for all of the remaining issues in the divorce to be taken care of. Now, so for those reasons, what I'm going to do is deny your motion as untimely. This is the motion to enforce, but I'm not making a judgment on the merits of it, meaning if after the judgment itself is signed, which I understand includes, after the judgment is signed, if your husband, ex-husband at that point, does not comply with it for whatever reason, then you are welcome to come back to court on an order to show cause, or request to show cause as to why you shouldn't be held in contempt for failure to comport with that order. Do you understand, ma'am? Ms. Geiger, do you understand? Mute?
No, I'm not on mute.
Okay. All right. So you're just choosing not to respond then?
What response is there?
Well, the response is that I've denied your motion that you brought in November, and I denied it as being untimely because there is no order in place that's being challenged, but I'm not denying it on the merits. That means you can bring the issues up again at some point after the judgment is entered and you believe that your husband is not in compliance with the order. Do you understand?
Yes, Your Honor.
All right, very good. Let's go ahead and proceed then to the motion that's been filed by Ms. Jordan. That motion is a motion to enter the divorce judgment in this case. I've heard argument from Ms. Jordan regarding same. Ms. Geiger, do you have any argument that you wish to make with regard to the motion?
I'd like to know if the plaintiff's attorney and the parties of the court received the 5 notices that have come through since July regarding jurisdiction.
This is an issue that is not relevant to the question that I've asked you. What I've asked you is if you have any argument with regard to the motion that's been filed to enter the judgment. That's the matter that's before the court. Remember, I told you you are held to the same standards of ethics, procedures, evidence, etc., that any attorney is. You're choosing to represent yourself. So I need you to be responsive to the issues that I addressed to you. And that question is to you. Do you have any argument with regard to the motion that has been filed by?
I'm not trying to dishonor the court, Your Honor.
I didn't say you were. I'm simply asking whether or not you have an argument that you wish to make with regard to that motion.
I'm not here to argue, Your Honor. I want to settle the matter, but I would like the matter of the jurisdiction to be addressed. I'm here by a special appearance to handle this matter. And I do require due process under the law. Do I receive due process under the legal? And is there a difference between lawful and legal?
Okay. What I will let you do is make a motion if you wish to regarding jurisdiction, because you're now raising a jurisdictional issue. Jurisdictional issues can be brought generally at the beginning of the case in the first responsive pleading.
I did that. I did that at the beginning of the case.
I'm sorry. All right. Remember, I said we can't talk over each other. So you need to respect the court and allow me to say what I'm going to say for the record, and then I'll listen to what you have to say, okay? So once again, you're raising a jurisdictional challenge. Jurisdictional challenges generally must be filed at the beginning of a case. Let me go ahead and look at the file and see whether you filed a jurisdictional challenge. Hold on. Okay, we're going to go off the record for just a moment. And the court's going to address another matter. That complaint does admit to jurisdiction, essentially, or a ver jurisdiction, pardon me, at paragraph 1 and paragraph 2 with regard to the actual marriage of the parties. So it does appear to me that the defendant has waived the issue of jurisdiction by virtue of the pleadings that she filed in this case. So as a result, I find that the issue of jurisdiction is untimely at this point. All right. Do you have any other issues with regard to the motion that you wish to argue, Ms. Geiger, at this time, other than jurisdiction?
Yes, I do.
Great. You're welcome to go ahead and make.
The United States has never held any municipal sovereignty, jurisdiction, or right of soil in Alabama or any other new states which were formed. The United States has no constitutional capacity to exercise municipal jurisdiction, sovereignty, or eminent domain within the limits of state or else.
Hold on. If you're reading something, you're speaking too quickly for us to get this into the record, and I would prefer that you summarize rather than read. We do have several other matters that are scheduled today. So normally a motion like this takes about 15 minutes. Now we're well in excess of that already. If you could please speed it up and summarize perhaps.
I'm sorry, I have challenged jurisdiction. Anything that was prior to July is irrelevant. That was taken care of by an attorney that was fired for not doing their job properly, which is what has took place in the early stages of this proceeding. What I was citing is Pollard versus Hagan, 44 USC 213-221-223. No shame.
Is going to have to adjourn this matter. I've got a full afternoon docket, 5 matters to go before 5 o'clock. Reset it as soon as I possibly can. But I'm not able to hear the remainder of the argument today.
Wow.
Well,
And
Your Honor, Your Honor, I really
so
hope
we'll
that.
reset it and we'll let you know as soon as we possibly can. All right. Thank you all. We'll see you soon.
Thank you, Your Honor.
I'm Ty Warren. Mr. Warren is here. He currently does not have an attorney
Mr. Warren.
appointed.
Mr. Warren, you want to come on up and, all right. You want to have a seat up here? Would you rather stay where you are?
I'll stay here. then.
Okay, that's fine. We can still hear you and communicate well. So we're taking up the case 24-130. And Mr. Warren, you've filed this motion to dismiss the state's charge. And I've had a chance we were together, I don't know, a few weeks ago, and we set this hearing. And so I'm going to turn to the state here. I don't have anything filed.
That's correct, Your Honor. And when I was reviewing this late last week, it came to my attention that nowhere in the record did the court authorize the defendant to proceed pro se. And the issue the state has is we haven't provided discovery to the defendant. We haven't provided discovery to counsel for the defendant. And until he's authorized by the court to go pro se, we can't really respond to his motion either.
Well, I think we're at a motion, and this was filed in February. And since April of 2024, it's been clear, Mr. Warren, who's also to us known as Mr. Azeltine, but Mr. Warren is proceeding representing himself. And he's made it very clear in his pleadings, and I'll allow that. And it's been allowed throughout. So are you going to respond to this motion today?
I can respond orally to the motion, Your Honor. Yes.
Okay.
I do have to express some hesitation and concern here, Your Honor. The state currently has a case coming back from a Superior Court appeal where the court did not go through the pro se properly with the defendant, and therefore the court is overturning that case.
Well, this goes back to filing of April 2024. I haven't looked through all of the recordings, but I think Mr. Warren, I think it's been clear that you're wanting to represent yourself since this beginning. Is that right?
Yeah, let me make that clear. Without recourse, as my unrebutted affidavit on file in this case stipulate, I am not the ens legius, Mr. Azeltine. I'm not Mr. Warren. I'm a man. My mother called me Ty Warren, and I'm of the Azeltine family. Sovereign as spoken of in Yickwo versus Hopkins, and not the corporate artificial entity Ty Warren Azeltine in all capital letters, nor representing the defendant, Ty Warren Azeltine. I'm not here pro se. I'm here by special visitation, sui juris, in propria persona. You may call me Ty Warren. I'm here under duress and threat of arrest by special visitation, reserving all rights without prejudice under UCC 1-308, and refusing any contract not explicitly agreed to. For the record, I do not consent to the court's general jurisdiction over my person.
All right. So you're in a criminal court, and you have the right to be represented by an attorney or to represent yourself, to speak for yourself, put it that way. And not have an attorney represent you. So where are you?
I'm here to present myself as a man.
Okay.
Not as a corporate entity.
All right. And I think throughout, well, I know throughout we've talked about this whole idea about appointing counsel or not, and we haven't done that because you didn't want that. And I remember the times that we've been together. I can't speak for any other judges without looking at their records or listening to their records. So, and the prosecutor's office has been here throughout the times that you've been before the court. And the last hearing, April 8th, was when we cleared up that warrant and we set this hearing. So it's abundantly clear, and that Ty Warren here is speaking for himself or representing himself, and we're going to go forward on that because we've had those discussions for over a year now.
Again, I'm not representing myself or the defendant.
Right, I understand. So I see in the pleadings that you filed that there's at least one. First thing that might be most dispositive is the motion to dismiss based on Court Rule 3.6, which is a suppression of evidence, saying that there was no basis in the law for you to be stopped by the officer. So we're going to start there. Well, I'll make the record here as to jurisdiction and venue. I think I've made that record already, and I don't see anything. I'll hear from the state if there's anything else, and we talked about this at the last hearing, that this is the district court. This is an allegation of a driving offense under RCW 61, also an allegation of obstructing law enforcement. Those are properly filed in this court as they're alleged to have occurred here in Thurston County, and this court has jurisdiction, subject matter, and in personam jurisdiction. So venue is proper as well. So
I'm here to challenge that.
I understand, and that's part of your motions. Just making the record that there isn't any basis in your motions that have undercut that reality. So the court does have jurisdiction and venue is proper. So we're gonna hit that 3-6 motion. And I'm going to hear from the state as to what evidence they have to present. And I'm looking back to that motion. I think it's about 33 pages. It was filed back in February and reiterated throughout. So Mr. Thompson.
You're speaking of my affidavit?
Yes. And you've filed a lot of information. I've taken it all together. It starts out with that motion to dismiss from going back to, June of 2024. I misspoke.
You can sum it all up with my most recent affidavit.
Yeah, and that I'm also including in my reading, everything you filed. So now I'm going to jump to the state because they're the ones who have to defend against your motion. I will hear more from you. So, Mr. Thompson.
Thank you, Your Honor. And the sworn statement that our office provided at the initial hearing stands that the defendant was stopped for speeding, and during the course, that was the basis of the stop was speeding.
And so resting on that initial probable cause finding in April.
That was, yes, correct. That was the basis for the initial stop, which would give rise to the Terry stop for an infraction. And from that point on, the defendant refused to give name and gave a world passport ID card or world passport. I don't even know how to fully describe it accurately other than not a document from a government entity.
So anything you'd like to say more, Mr. Warren or Ty Warren?
Yeah, plenty to say.
As to that issue, let's kind of focus in on issue by issue.
What the prosecutor has just said. He stated that I did not give a name, and then he counteracted himself by saying I did give world passport ID, and then he said it was not a valid or whatever he said, and not valid or not recognized by the state. But whatever the case, I would like to present what I have to say here. I'm a man visiting here, especially not generally sui juris and the trial solely to challenge jurisdiction.
Let me ask you a quick question. Did you already file the information that you're reading?
No.
No, this is new?
Yes.
Okay. All right. You have an extra copy?
This is just my oral.
Okay. All right.
Printed out.
Let's see. Try and focus in on the motion to dismiss that you have for suppression of the evidence.
This is what this is all about. It's all about jurisdiction.
Well, we're not talking
has been
jurisdiction.
proven on the record, and I have seen no proof of jurisdiction.
Talk to me about your motion to suppress. Talk to me about your allegation
I'm
here.
here to establish jurisdiction or not.
Well, I've already maybe I should be more
There
clear.
are no facts on the record.
I
about
deny your
jurisdiction.
motion as to jurisdiction in this court. So this court has jurisdiction
You
and
haven't even
venue.
heard
What I
have to
need
say
to
about
hear
it.
from you is what do you have to say about your motion to dismiss for
I
a
can't say
bad stop?
anything about a motion to dismiss
Okay.
until jurisdiction has been established.
I've denied your motion. This is the correct court. We have jurisdiction, so move on. You can disagree with the court's order, but you can't make it better by just continuing to argue about it. So let's move on to that other motion that potentially is dispositive, the stop.
One moment, please.
Sure.
I respectfully object to that ruling and give notice. I contest the court's assertion of jurisdiction all the way. Let the record show that I timely and persistently challenge jurisdiction, and that challenge remains unanswered by factual evidence.
Anything else? Just looking back through your affidavit and your motion. Anything else for me to consider from
Yes,
you?
Like I said, I have plenty to consider.
Okay. About, first off, as to this motion to dismiss.
The jurisdiction argument has become a strategic trap. The judge has already ruled on it, so repeating it does not strengthen the suppression motion. The key mistake is refusing to move to the issue that could actually decide the case.
It's based on the bad stop, is what you say.
Yeah. Excuse me?
Your motion to dismiss based on a lack of good reason for the stop. That's what I'm first dealing with.
I can't even address that issue
Okay.
without jurisdiction being established.
Okay. All right. Well, all right, Mr. Ty Warren, Mr. Azeltine, however you want to be referred to. So this is the deal. I'm granting your motion to suppress all evidence after a stop. I have no evidence presented that I can consider. This was filed by you in April of 2024. And there's been affidavits and information filed thereafter, all in the court file. We've set this for trial, or we've set this for a motion as recently as April 8th. State was present. It's kind of like, for whatever reason, the state decided not to join or prosecute. So under Rule 3.6, I don't have any evidence to overcome what your assertion is that you were peacefully driving down the street. And simply the probable cause statement from the beginning to allow the set of release conditions is not sufficient. There isn't anything other in the court file, in the court record, that would allow the state to overcome your motion to dismiss or to motion to suppress evidence. So all evidence obtained, stop forward, is suppressed or not allowed to be brought forward in trial by the state against you. So with that ruling, Mr. Thompson, from the state's point of view.
I believe the court is, well, I have nothing to add, Your Honor. The state will be filing an appeal.
All right, so are you saying that with that order of suppression, state, you're thinking an interlocutory appeal and able to go forward?
Yes, Your Honor.
Okay.
Well, I suspect the court intends to dismiss the case at this point. So I don't think an interlocutory appeal is what will happen, but an appeal nonetheless. You know, again, the state stands by its position that I put into the record regarding his appearance today pro se. I still do not believe that the court has gone through it properly. I will note one additional thing for the record, that in his motion to dismiss, he specifically says that he's doing so under duress, which calls into question the validity of any of his filings. And the reason why the state still believes, even over his objection, counsel should be appointed, because he is not here of his own free volition, as he said more than one occasion in more than one filing.
It's clear to the court he is throughout all of this. The semantics that he likes to use are not persuasive to the court. So, but as I said, the prosecution's decided, not to present. So, as we know, Mr. Azeltine, as we know you as, This matter is dismissed, given that suppression of all the evidence, and you're free to be on your way.
Thank you.
Thank you, sir.
What makes these three cases interesting is that the courtroom consequences did not follow the arguments in the way the defendants seemed to expect. In the first case, the defendant repeatedly challenged jurisdiction, the meaning of legal terms, and even the authority of the court. The judge's response was not to debate every theory. She simply kept the case inside the rules that actually govern that court. The result was a clear warning. Legal language only has value when it connects to a recognized procedure. The second case shows a different problem. A person can have a real dispute about a divorce agreement, property, or compliance, but the timing and legal vehicle still matter. The judge explained that an agreement is not the same thing as an enforceable court order until it becomes part of the judgment. That distinction mattered because the motion was denied as untimely, while the underlying issue was left open for a later enforcement proceeding. Then the third case produces the biggest lesson. The defendant spent much of the hearing challenging jurisdiction and rejecting the court's description of his legal status, but the ruling that actually changed the case came from a completely different place. The judge found that the state had not provided enough evidence to overcome the suppression motion, so the evidence was excluded and the case was dismissed. The prosecutor then said the state would appeal. That is the difference between a theory that sounds powerful and an argument that changes the legal outcome. In court, the decisive question is usually not which side has the most unusual terminology. It is which argument connects to the rule, the evidence, and the remedy the judge can actually grant. And sometimes, the biggest consequence comes from an issue completely different from the one receiving the most attention.